A message from our sponsor. Need a current or retrospective SMSF property valuation? Whether it's for annual financial statements, pension commencement, or related party transactions, SMSF Property Valuations offers fast, reliable, and audit-ready reports across Australia. As an accountant or SMSF trustee, do you need a valuation that satisfies ATO rules, includes documented methodology, and ticks all audit boxes? SMSF Property Valuations delivers an easy online ordering process to finish the job quickly. Hello, everybody, and welcome to another edition of the Cross Country Super Podcast. And as usual, I'm joined by Gemma Sanderson, all the way from Perth. It's
Hi,
great to
Darren.
see you, Gemma. How are you?
I am good. I am good. It looks like it's summer here, but we're just starting to get a bit cooler, but it's always hit and miss. Sorry, it looks like it's summer only because of what I'm wearing. But yeah, it's starting to get a bit cooler over here. So that's quite nice. I like this lead into winter, and that means lead into the end of financial year, which is always very busy. But yeah, we're
Yeah,
good. We're good.
I must admit, I hate this time of year, but but because it means the end of summer. But I've always thought that Perth has got a great climate.
Yeah.
Um, very sort of mild winters, which is kind of nice.
Yeah.
Not dissimilar to Sydney actually, but I still prefer a warmer sort of climate. So Queensland always appeals to me during the winter months. But anyway, we digress. We've already
We
gone off
digress
piste,
already.
and
Whoops.
not even a relevant piste.
No.
Actually, we're totally on a separate run here. But look. Followers of these podcasts will know that in the last episode we discussed the merchant case, which is obviously a very important case in the world of SMSF because it just touches on so many issues to do with self-managed super and superannuation. So many, in fact, that we've actually had to split it into two parts. And we did part one last time where we focused on what the implications of the decision of the case were for the investment strategy and for the sole purpose test. And the other two main takeaways we're going to discuss today, which involve the uh, the offering of financial assistance um, outside of the fund, and also to trustee disqualification as a result of a compliance issue, such as the one in this case. There's also been a recent development, so if you stick around to the end, we'll touch on that as well. And that literally was only just handed down. So another aspect of this
Tidbit.
case that just keeps on
Keeps
giving,
on
really.
giving. Keeps on giving.
Um,
Yeah.
so this is, I described it today in an editorial meeting as the case. I think this is the SMSF case of the millennium, personally,
I don't
because.
know. I feel like Gainer. They're on par. Like they're interesting. Lots of different facets of them. Oh, they'd be. We can have a debate about whether one's better than the other. Anyway, it always keeps us nerds very excited when we watch or see these cases unfold. But yeah, there's a lot going on in it. And I think, and I interrupted you, Darren, so I apologize.
That's all right.
I think the other consideration with this is this deals with obviously we're talking about the super fund, obviously, but because it's got other aspects of it outside super with the family trust and the advice provided by the tax agent and the auditor at the time, like all of those compound like implications compounding, that's where it starts to get a bit more, the tidbits in there that we like to be aware of.
Well, Gemma, in defense of my labeling of this case, we only did one episode for Gainer and we're doing two
Yeah,
for this one. So
fair, fair.
that's my argument and I'm sticking
Yeah.
to it, right?
Yeah, yeah, yeah. No, no, no. It's a very valid argument, Darren. Valid argument.
So we're not going to go into the absolute details of the merchant case. You can refer to the last podcast. Just a bit of a refresh. It's just about the owner of Billabong who basically acquired shares in his SMSF from a family trust. in order basically to offset a capital gain in the family trust with a capital loss, and using the SMSF to execute the transaction in order to generate that capital loss. And basically, from that point in time, a lot of other issues too, but from that point in time, it's sort of spiraled into, well, there are all these issues with from a super fund perspective that you shouldn't have done, and there are actually compliance breaches too. So today we're going to talk about the aspect of financial assistance, and yeah, over to you, Gemma.
Right.
At,
Well, let's get it
like
started.
how do we address how this issue came up with this transaction?
Um, yeah, it like you said, very interesting. And because initially when you look at it, you'd think, oh, well, Section 66 says a fund can't acquire an asset from a related party unless it's with respect to, there's a bunch of exceptions. One's business real property, which we're not talking about here, but one's listed shares. So these were shares in a listed company. They were done at market value at the time. Transferred off market was about $6 million, not quite, worth of shares, and it crystallized, I think it was a $12 million capital loss rather, in the family trust. So that was the benefit of that to the trust, was that they wanted to use that to offset a substantial gain coming through. Anyway, Section 65 of the SIS Act talks about financial assistance, where a super fund can't be used to provide financial assistance to a member or a relative of a member. And by and large, that's the consideration where money gets loaned. I'll use my inverted commas here, loaned out of the fund to a related party or a relative of a member from that perspective. And so in this case, we're thinking, well, financial assistance, how is the fund who bought these shares for market value at the time, it had cash, it paid market value for them. How is that providing financial assistance to a member or a relative of a member? Now, that member slash relative of a member is also given some extension to looking at that via an interposed entity. So if you have a look, there is a tax ruling or an SMSF ruling. I'll tell you, it's SMSFR 2008/1. So it's some 17 years old, but it's still very relevant because that particular SIS provision hasn't changed. And that talks about, it's a 50 odd page ruling. So for those of you who have some insomnia, you can have a read through it. But it talks about, if my super fund directly says, here's $100,000, Gemma, and that is treated as a loan, and the tax officer's view on those sorts of loans is there needs to be a loan agreement and all these sorts of things. Otherwise, it would be a legal early release. So if that was a loan from my super fund to me, we've got a breach of 65. But let's say that my fund didn't lend the money to Gemma directly, it lended it, or it loaned it to Gemma's trust. And then from there, is that because that's not direct to the member, but then what does the trust do with it? If the trust then advances it to me for personal purposes, then we've got a 65 breach. If the trust then uses it for investment purposes, then we're looking at in-house assets. In either case, 65 goes hand in hand with the in-house asset rules because it's a loan to or an investment in a related party. So in this case, the financial assistance consideration was, well, we haven't given cash directly to the member. We haven't given cash directly to the member's children. We've bought shares at market value and received something in return. So how is that financial assistance? And the way that that sort of flowed through was, because of the transaction, the financial assistance was then the loss that it generated that would then benefit Mr. Merchant and as the primary beneficiary, and his children as beneficiaries of that trust. So that's where the financial assistance was considered. Now, you might think, oh, well, that's a bit of a long bow to draw, but with when you look at the entirety of it all, which the breach of the sole purpose test, because the sole purpose of transferring the assets or undertaking that transaction, or the predominant purpose, was to crystallize a loss. It really wasn't for the benefit of the fund or providing the retirement of the member or their beneficiaries or to their beneficiaries on death as per sole purpose, because of the further things that happened. So because of the outcome being that he benefited and he was the member, he benefited because he was a beneficiary of the family trust, as well as his children, again, relatives of the member. They were the wider beneficiaries of this overall transaction. Then that's when Section 65 was considered to apply.
Yeah, it's really interesting, Gemma, isn't it? Because I'm probably one of the naive individuals who looks at, or who did look at financial assistance probably on a face value or a really shallow perspective. Like you said, the obvious ones are when the fund directly makes a loan or loans money out to particular parties. But this is a real extension of that principle, isn't it? Whereby, a loss generated can, in a family trust, because of the transaction with the SMSF, can actually provide financial assistance simply because it offset the capital gain that that they would have experienced in that family trust, and obviously looking at a tax liability there, and so it lessened the tax liability, if not completely offsetting it, and so they actually got a gain from that tax
No,
position.
paying no tax. Yeah.
Yeah,
So,
exactly.
yeah.
But there's a what got me is that there's actually quite a few steps to process that when
Yeah, that's
looking at
right.
that, and that's certainly something to take into account, but not something that's really obvious. And so it's
That's
probably
right.
well, and I'd stick my hand up. It's probably an aspect where I thought, oh, really? But I was only looking at it from a very basic level, and this again, layers of the onion type stuff. This, this goes to show that, well, no, you've got to go a little bit further than that, and while it might, as you said, it might seem to be a long bow to draw, it's probably irrefutable that the dots can be joined
Joined. Yeah,
get
that's right.
to get to the outcome that, actually, yeah, this is a compliance breach.
And now, because I know you said, wait to the end, everybody, and I'm going to, ruin it. So, one of the arguments for the fact that it wasn't a breach of 65 and then also wasn't a breach of the sole purpose test, and if, like, not the investment strategy was an issue anyway, was the fact that the tax office denied the loss. So, it couldn't be seen to then be a breach of sole purpose because you didn't get the loss. So, how? But it was obviously the intention at the time. And not dissimilarly, you could have a look at, well, if the loss wasn't allowed and therefore that benefit didn't flow out to the beneficiaries of the trust, and which were the member and the member's children, then have you really provided financial assistance because they're not getting the benefit on the other side? So anyway, that's an interesting not counter argument to any of this, but consideration in where that loss was denied. And that was, I will ruin it now. So the taxpayer appealed the decision where, and this wasn't on the super fund side, the taxpayer appealed the decision with respect to it being Part 4A because of the loss, because it's effectively a wash sale. And there was another element in that particular federal court case that dealt with TOFA, taxation of financial arrangements, which was more to do with the overall transaction of the sale of the particular asset that gave rise to the gain in the trust. Anyway, blah, blah, blah. And his appeal has been dismissed. So what that does mean is that the loss has been denied. And whether so now the expectation is that we will see the action that the taxpayer had brought against their advisor to pop up again, because that had been stayed waiting for the outcome of this matter. So anyway, that will pop up from that perspective. So I think that was one of the big considerations that the Mr. Merchant's team put as an argument, saying, well, have we really breached sole purpose test and financial assistance because this loss has been denied? But the intention consideration in 62 is that's prior to any of this. You intended to get the loss. Just because it was denied doesn't change your intention at the time. And the purpose, predominant reason and purpose for the transaction, 65 is an interesting one. But in any event, there were all sorts of other bits and pieces to deal with, which we'll talk about, the disqualification. And you probably will jump in, but I think the implications of this 65 consideration is, again, on the very, very face of it, you'd almost look at, well, it was a bit of an innocuous transaction of shares being acquired by the fund for cash at the prevailing market value at the time. So if you just sort of looked at that in isolation, and what that is going to mean is for advisors in the industry is a lot of those transactions happen. Look, you don't want to, a lot of clients don't want to sell down particular investments, but perhaps they want them placed in their super fund. So they then look at the consideration of, okay, well, the super fund's got cash, let's buy it out, et cetera, et cetera. But I think it's just going to require some additional considerations there and a bit more scrutiny, especially if it's going to result in a loss being generated within the related party entity, because then you don't want to be caught under this consideration. Because, like you said, most people were, a loan. It's a loan. It's either a loan to the person, loan to an amount to the trust that then gets used by the person for personal expenses. There where 65 catches you. But now it's a much wider net that it can potentially catch. And so we do really need to be mindful of the implications of this outcome.
Yeah, you raise a great point there, Gemma, with the machinations of this, and it's not really reality versus perception, but they are arguing obviously reality now that the tax loss has been denied. That, well, in reality we didn't actually get it, but you do raise a great point with, yeah, but you intended to do it, because
Yeah,
as difficult as that is a concept to sort of grasp for a lot of trustees, and it can be a little bit, um, flippant, I suppose, looked at in a flippant way, not flippant from the point of view of flippant about compliance, but flippant about expressing what your intentions are. I mean, it kind of in a lot of ways goes back to buying an investment property, and it could be, oh, I want to acquire that because that's my dream house, but I'm going to use my SMSF to do it. Well,
yeah,
if you actually communicate that, you're in a bit of trouble. I know that
yeah,
sounds a little bit silly. And this can be sort of for sea change properties and that sort of stuff where people are looking ahead to say, oh, I can use my SMSF as a vehicle to do that. But if you declare that intention, again, I know we're not talking about the sole purpose test right now, but you can be in breach of that. And it can be a flippant statement
mm,
about, oh, Gemma, I saw this sensational house on the weekend. I'm going to put it in my SMSF because guess what? I want to actually move into it a little bit
when
further
I
down the
retire.
track.
Yeah, yeah,
Yeah,
yeah, yeah,
that's right. And that's not, I mean, it can be a little bit throwaway in terms of communicating, what you're trying to achieve.
yep.
And again, we're not saying that that property won't necessarily appreciate in value, and you can even rent it out if you want, obviously,
Well,
while
you'd be wanting
super
to, I would
fun.
have thought, to
Exactly,
start with,
exactly.
to
But
randoms.
yeah,
Yeah.
exactly. But you've already communicated that that's not that's not the reason why you purchased the asset in
Not
the
your main reason for
yeah.
purchasing the asset. Yeah,
So
that's right.
that whole intent thing is really, really critical to what you do and the strategies that you might try and implement in your fund. And some people might say that, oh God, that's a bit unfair, isn't it? I
Hmm.
mean, who am I hurting? Like what did I do wrong? I don't understand what I did wrong, but But this is kind of how finicky some of these decisions can get if you do get picked up by the ATO and, you get entangled in these webs of having to defend a particular transaction or what
Transaction.
you
Yep.
did. Yeah.
And what happens, so that, like you were talking about, that purpose side of things, there's other areas in the tax law that talk, like the GST Act has certain bits and pieces about what your intention was and did that intention. So you might have bought a property for the purpose of renting it out, but then that changed and you bulldozed it and you built new premises on it and you did various sorts of things. So from a GST perspective, there's different elements that can come through. From a CGT perspective as well, is it trading stock or is it the mere realization of a capital asset? There's the other bits and pieces in there that your purpose or intention at the time may well have been one thing, but then it changes, or that's where that sort of flows through. Anyway, it's quite interesting. What is your intention at the time? And in this case, blind Freddie could see that the only intention here was to get a capital loss, so that flows through. But the wider, so in this situation, it was just a single one transaction that did it. But we certainly see situations where people have, say they've got a share portfolio in their own personal name or in their discretionary trust, and they want to contribute that into super. So that's the acquisition of an asset from a related party. So Section 66, are we ticking off on that? Okay, yep, it's listed shares or it's widely held managed funds. So yep, tick. Then we're looking at, right, well, that particular share, so miscellaneous share, has a substantial capital gain. So, right, if we move that as either transfer it as a contribution or we've got the consideration of paying for it, then that's going to crystallize a capital gain in Gemma's trust or in Gemma's name. But she's got 5 other assets that we're also looking as part of this, which she's going to move, and then it'll be neutral or the gain will be reduced substantially. Now, is that going to, so this decision, will that alter how that gets looked at? Because all of a sudden we're thinking, oh, well, the one with the gain, that'll be all right because there was a gain. But the other ones, what was the purpose of moving them to crystallize the loss to offset that gain? It's almost a similar, now it'll be on a much smaller scale, but is that a consideration? Because the other thing with and now I'm talking about contributions and all that sort of stuff, is back in the day when CIS regulation 7.043 was around, and I've got a brain that remembers all these bloody sections. And that was when a single one-off contribution, if you put that in, and that by itself was in excess of the contribution cap, then you could refund the excess amount of that particular contribution. And there was a whole bunch of ATO IDs that came out between 2007 and 2010. And there was, I think it was 2007. Anyway, I can't remember the exact one, but there was one of those ATOIDs was about what is a single one-off contribution. If I contribute my share portfolio into the fund, is that a single contribution, or is every different share a single contribution? So say it was 5 shares. Is it one contribution? Is it 5? Or within each of my share parcels that I had, there was 100 shares in one, 1,000 shares in another. Is it times by however many those are? And so, so what is a single one-off contribution? Ultimately, each share parcel was a single contribution, not the portfolio by itself. If you did a single cash transaction, that would be a single one-off contribution. But for people, so it would generally be a single one-off cash contribution that would then trigger a release or a refund rather than share portfolios. So if each parcel of shares, I'll get to my point, if each parcel of shares is considered to be separate and independent from that perspective, is that going to be a consideration when we look at these transactions? So I've got my share with the gain. Okay, well, that's all right because there's no financial assistance to a member. The fund is receiving or acquiring it at market value, and that's a contribution, or it could be paying for it. But what about these ones that are in a loss position? So it comes down to, am I going to fall foul of 65 if I'm using some of like crystallizing those losses. There's no change in economic benefit or economic. I've still got exposure to those shares in my overall family group. I've just moved that into my super fund. Is that going to change or result in an issue under this Section 65? Now, again, we've got to look at the merchant case with the overarching all four of the issues, including the investment strategy. So because those Billabong shares, because they were added to an existing portfolio in the fund of Billabong shares. It almost doubled the number of shares that were in there. They weren't liquid. He was in pension phase, all of these other things. So the fund had to stop his pension because it didn't have the cash flow. So there's wider considerations, but I think that as advisors, we just need to be considering what is the risk factor here. Is there a risk factor? Do we just exercise a bit more caution? Because the other thing with this is if he had sold those shares on the market, then none of this would have come through, because he was, then there was no change in economic in his. So there was a change then in his shareholding in Billabong across his family group, and that's where those wash sales. There's that taxpayer alert that deals with wash sales. So anyway, we're talking. It does look like a long bow to draw. It was a single transaction, a substantial one, and a substantial shareholding in a single asset that is going to be distinguishable to, I think, more wide transactions, but just to be aware and factor it into your considerations when you might be advising clients on the transfer of shares into super.
Yeah, I actually think that the significance of this case is that it was a single transaction. I mean, the scenarios that you went down, obviously, people would accuse, compliance scrutinizers that if you're talking about five separate transactions and what the gain and loss are of a particular one, two, three, or four, and individually what happens, then the analysis of really financial assistance for this one, but not this one, when it
Mm,
was kind of like a group. That gets a little bit more complicated. But in this case, it was just one single
yeah.
transaction. So it really is a pretty clear-cut example, I suppose you could say, without muddying the waters to say, oh yeah, but that was a really intricate scheme. It involved, 10 different transactions before you got to the final result. And yes, the final result was considered providing financial assistance to
Mm.
another party from the super fund, but there were a lot of steps to get to that, and I can understand that somebody couldn't see it from that perspective. If there are a lot of steps in the way to get there, but in this case, it was one, I wouldn't
It
say
was one. It
single
was, yeah,
transaction. It was
that's
just
right.
one transaction. So it's not even as if, um, you can argue that there's any obs
Obfuscation.
yeah, that's the word I was
That's such
looking
a good
for.
word, isn't it?
That
I love
that
it.
there's an intricate web that has been woven here. This is just one, and it's a share sale and share purchase as well. That's arguably one of the most basic transactions that you can
Mm,
execute in an SMSF.
yeah, that's right. Cash for shares, like
Yeah,
single
I
transaction,
know.
easy, easy. Yeah. Um, but then of course all the little webs behind it that led to it all. And I think that that probably dovetails well into us leading to talking about the disqualification element,
Yeah,
because
absolutely.
initially a single transaction gave rise to financial assistance, Section 65 breach, a breach of the sole purpose test, and then a consideration that the investment strategy hadn't been considered. So, because of the scale of the breaches, then the commissioner sought to disqualify the trustee. And this was an area where he was successful in the AAT matter, where he wasn't disqualified. However, initially, so when the tax office looks at disqualification, when they are, because the so under the disqualification rules in the SIS Act, it's around section 120, 126, and it talks about you're automatically disqualified in certain circumstances. So when you are convicted of a crime that has a certain sentence and all those sorts of things, the dishonest conduct, I think it's 2 years, more than 2 years of your sentence, all those sorts of things. But then the regulator can also disqualify you. And there's a practice statement that they have that they go through, as in the tax office employees would go through this and consider whether, look, is it valid for us to disqualify this particular trustee because of the breaches and their conduct? Now, that is practice statement 2006/17. So again, that's a very old, nearly 20 years old, that particular document. But it remains valid. Those particular provisions haven't changed. But what we have seen in recent times is the likes of Merchant looking at, well, what does disqualification mean? We also had Coronica on a more recent basis. There was another one recently, but I can't remember exactly what name was. But Coronica stuck in my brain because it was when we were going through the coronavirus. So I don't know, just sort of stuck there. So they go through a whole bunch of different considerations. So initially the tax office was saying, well, because of all these breaches, you're not a fit and proper person to be running, to be the trustee of this fund. The severity of the breaches means that we don't consider, we think that you should be disqualified. And, one of the elements they have to consider is the future compliance risk of the fund. And that was also a consideration in there. Now, ultimately, before they sort of went to court, the tax office pulled back on that fit and proper person. They confirmed that they did think he was a fit and proper person. So that was one element. And then usually, if you get advice from your tax agent or financial advisor, or I'll use the term advisor quite widely, if you get advice from that person, that does not protect you against any of these things, because ultimately it is the trustee's responsibility. Ultimately, it is the taxpayer's responsibility where you're talking about wider tax. So you might get advice, you might have sought advice, but ultimately the taxpayer is the one with their head on the chopping block. Now, in this situation, in the tribunal decision, the fact that he had advice helped him, because the consideration or the comment was, he hadn't, I think we've covered this already, he hadn't had advice on the super side of things at all. He'd had it on the tax side with respect to his family trust. However, it was the same firm and the same partner that was involved. And so the consideration, one of his arguments was, well, the guy who advised me on my, in my left hand, he's the same guy that does my super fund. And so if on the left side it was great, but then I would have expected, my expectation was that if there was an issue on the right side, that he would have identified it because he was the tax agent and the auditor for the fund, but that never arose. And so the outcome of that was, well, that was a reason for the disqualification not to hold, because he had advisors, and it just, even though the breaches were significant, that was a tick in the right box from that perspective. So there's lots of different elements here with the disqualification, and you see it also in Coronica, where the initial outcome of the case was, the commissioner's decision to disqualify was overturned, and then they appealed, and he was disqualified in the, I think that went through the federal court. So, but that was certainly one of the elements. The other thing was, significant breaches occurred. So 65, 62, the investment strategy, there were the main ones coming through. The other consideration for the commissioner is, what is the future compliance risk of the person? And they had said, well, all these things have been breached. There's substantial, significant breaches by monetary value, and therefore we think there's a future compliance risk. The outcome of the AAT decision was saying, look, the compliance risk is, it's his money. So it's not a public compliance risk, notwithstanding that, if you're not paying your taxes right, that impacts all of the taxpayers in Australia. And so that was helpful. And then the reason why I dovetailed when we were talking about a single transaction is that also helped, because it wasn't multiple breaches of 65 and 62 in the investment strategy over a long, long period of time, or even over the course of a year. It was one transaction. So a single course of conduct that led to these breaches. And yes, the breaches were significant, but that did not lead to that the disqualification then didn't hold.
Gemma, I thought you were going to say that you remember the Coronica case or the Coronica case because you like Corona beers, not because,
Oh, well,
not because of the
yeah,
coronavirus. But
virus.
anyway, I digress.
You
Um,
digress, yeah.
this is certainly, I know that in all of the topics that we've covered associated with this case and with this decision have almost been warnings for
Mm.
SMSF trustees and SMSF practitioners not to allow your clients to go down this path because there obviously are serious implications for them. But this is probably a silver lining
Yes,
if
yeah.
there can be a positive from this case, this is probably one that is a bit of a silver lining. And I think also, didn't Mr. Merchant agree to rectify a lot of the stuff that he did and become more, I think he committed to becoming more transparent with what he was doing and documenting
Yeah.
stuff more in the future so that there couldn't be any confusion around whatever future
Intention,
transaction for
intent, yeah. And the
with
other
the
thing with
funds
that
would be.
was, yeah, yeah. So there was that, and he had represented that any future investment decisions would would be consulted an investment advisor. So wouldn't just be him making those decisions himself. He would obviously, as a trustee, be signing off on that, but he would consult an investment advisor to make sure it was in line with the investment strategy and all those sorts of things. So he had represented and made those assertions that were also part of the reasoning behind that. Yeah.
Yeah, so obviously, I suppose that demonstrates or indicates some
Mm.
level of contrition as
Yeah,
far
that's right.
as maybe and of course, I'm sure he didn't even know what the consequences would be. But now that
Oh,
he does
absolutely.
know, he says, "Yep, okay, what can I do to make this right in the future so I don't trip up like this again? Okay, I'll agree to do this, and this. They should be enough safeguards at least to ensure that my fund won't fall foul of the rules that I've breached now. So, clean slate, let's move on into the future. I commit that I won't do this sort of stuff again, or at least if there's any chance that it might happen again, there are safeguards in place that a red flag will be raised and a potential egregious transaction will not go through. I mean that's a big one, and I think it's probably a just decision as far as that goes because
I think
if the
so too.
trustee actually commits to that course of action, he's not. I understand if the powers that be decide that, well, this bloke's not showing any sort of contrition at all. In fact, he's just blowing it off as if he's been unfairly treated, and he's not going along with it. But he's actually acknowledged that okay, this is what's happened, but I'm going to be better in the future. I'm going to make sure that there are things in place for me to be better as a trustee running my super fund. And I think, again, from a just point of view, yeah, I think that sort of commitment should be looked upon favorably.
Yeah, I agree. But I also think that part of this was he almost had those mechanisms in place already, which was he had a superannuation tax agent and auditor there who were the same people advised, like holistically advising him. So you would expect that that would have all been identified as part of their role from that perspective. It does bring up the that independence consideration because it was the tax agent and the auditor were one and the same. And so, you don't have that an independent review. Although in saying that, if the firm had done the tax returns for the fund and then had advised, there was that advice on, yep, you can do it and there's no breach of the super fund. By the time the auditor got involved, that ship would have sailed. They would have already had all of the breaches sort of thing happening. So that certainly does help, that the consideration of, yep, I'm now more aware of what my obligations are, even though everyone should be aware of their what they should be doing. But of course, most people outsource the management of their investments, the administration of their fund, and so this would happen a lot more than that people are really unaware of what the issues and rules are, because they're relying heavily on their advisors, the people that they pay good money to make sure that they don't fall foul of these particular rules.
Yeah, and I mean, it's the most rude wake-up call for Mr. Merchant, but it's a
Mm,
wake-up call for the whole SMSF community about, how one transaction can just
mm, yeah,
completely spiral out of control and lead you to all of these compliance issues. But at least, again, as I say, it would appear, and of course, actions speak louder than words, but it would appear on the surface that he's heeded the wake-up call and
mm,
he's going to do something about it. Now, whether or not he does, and I don't know whether or not this name or this case will rear its ugly head again, as in subsequent chapters
mm,
to the merchant case. We don't know that, but you can only take a trustee or a plaintiff or a defendant, sorry, on face value to say that, yeah, I will do this. I have no doubt that some of his actions will be monitored pretty closely to see whether or not
yes, yeah,
he will do this. So it would be probably a silly thing to be seen as thumbing your nose because you don't follow through on the commitment that you said, yeah, but I don't deserve to be disqualified because, I'm contrite and I want to do this. Well, you better do it because I'm pretty sure that, and of course, this is a decision that was from the ATO that was overturned. So I'm sure they would be monitoring this situation fairly closely,
closely, yeah.
just to ensure that, okay, well, yeah, we don't mind that it's overturned, but we just want to make sure that you do what you say you are going to do.
The other thing that is, when you consider that as well, is this single transaction happened, I think, in 2015 or 2012 or something, ages ago. And so,
Yeah.
yep, I'll do things properly now. Well, that won't have been in the intervening 10 plus years. It would just be from that particular time frame. So, again, timing, these things, they take a long time to go through litigation and all those sorts of bits. But I've got the decision. There's a decision impact statement that came out from after the AAT decision, that the ATO released about the super compliance breaches, and then the fact that the disqualification came through. So, in this situation, the tribunal decided the commissioner's decision to disqualify should be set aside, and it goes through. So the tribunal agreed with the commissioner that the applicant was a fit and proper person. So I did mention that earlier. That had given undertakings, which we were just talking about then, which were accepted as appropriate and reasonable and mitigated the risk of future non-compliance. Okay, so the other thing that they spoke about was this advice side of things. The tribunal accepted that okay. Right. So, although the breaches were serious, the circumstance that the transaction was put forward by the advisor, which had acted both in the capacity of the merchant group's tax agent, but was the fund's auditor. And that was what it says, a significant mitigating factor. The advisor had put forward the arrangement without raising an issue from a super compliance perspective. While it was acknowledged that the advisor advised that there were tax risks, that was a different issue to the issue of super compliance. In those circumstances, the tribunal accepted that the applicant would have fairly thought that the transaction was lawful from a superannuation compliance perspective. So because the advisor they were silent on identifying the risks, etc. So it was like, well, it was implied a complying transaction because there was nothing to say that it wasn't, and that was that mitigating factor. So again, it comes back to the advisors being aware and making sure that they have got that holistic approach across everything, because you don't want to be the next merchant where I've deliberately not named the advisor or the firm, but you don't want to be that person that's all through the courts and stuff saying, yeah.
No, so let's hope that Mr. Merchant does follow through on his commitments that he made to be a better trustee and more
Mm.
compliant trustee in the future. And let's hope we don't go down the Star Wars saga of this being episode 4, and we have
Yeah,
5, we have 6 down the track. So I got it in there.
you
So,
did get it in there.
so that's good.
You did
But
do well. Yeah.
as you mentioned, I mean, we might move on to the latest development in this case because you were mentioning advice and what happened there. It's
Yes.
again, this is another layer of the onion if you want to say, but this is looking at it not necessarily from a self-managed super lens, even though obviously it's all intertwined in the mix. But this is now moving on to what implications will it have for advice practitioners out there in
Yep.
situations like this, when it all goes a little bit
Awry.
awry. That's the word I was looking for. Not doing very well for a journalist today, am I? I can't find any of the words I'm looking for. And awry, not again, not from a sneaky perspective or an overly, how can we be clever by too
Mm.
clever by half? Probably a well-intended piece of advice and transaction, but it's all come a cropper.
Yep, that's
Big
right.
big implications.
Yep. And I think that's and as a result of obviously one of the big four firms got absolutely reamed by the government and the tax office and all the professional bodies on the tax chap they're using insider knowledge to advise his big clients. So
Yeah,
there's we've had that scandal in the last 18 months, if 18
yeah.
months to
About
2 years.
18 months to 2 years, yeah.
And so it's interesting that this case, the merchant case, and I've been involved in another one recently where it's the taxpayer or the trustee getting advice or having advisors is like I said before, it's not the response. The buck stops with the trustee or the taxpayer. So if they get advice, usually it's just okay, good on you, but that doesn't prevent us from coming through and having a look. Now, there's this is all about penalties too, as well. So there's 3 different penalties. One is your failure to take reasonable care. So if it is a bit contentious, the transaction, then maybe you're as a taxpayer, if you're overly cautious, then you get your tax agent or your tax advisor to prepare what's called a reasonably arguable position, and you put that in the bottom drawer ready to bring it out when someone comes through. Then you've got recklessness and intentional disregard. So the if you failure to take reasonable care is a 25% penalty, then it's a 50% penalty and a 75% penalty on the tax from the tax perspective. Now, like Mr. Merchant had advisors. So again, even though the buck stops with him, like the decision impact statement, which was referencing the case anyway, it was a substantial mitigating factor that he had advisors there advising him. And what I'm also seeing on other matters is that is a mitigating factor, and the taxpayer is almost being attacked, or the tax office is trying to get at the tax agent or the tax advisor via the taxpayer, because the tax office can't do anything direct with the taxation advisor or the tax agent, save for report them to their professional body and all those sorts of things. But a taxpayer that's going to be on the hook for way more tax than expected or substantial penalties because they've had poor advice, they are going to generally call their lawyer. And like with Mr. Merchant, where the action against their advisor was stayed pending this appeal decision, it will be really interesting to see the outcome of that. Now, that might be now behind closed doors with a settlement or mediation, so we may never know what comes out of that. But it just in I feel like with the lens and then the landscape of the big four firm that did the wrong thing with the intel that they had and advised their clients, that now we're all a little bit, and then we've got the Tax Agent Services Act changes coming through, the DOB, the dobbing provisions that are coming through in
Yeah.
there. It's becoming like a lot more challenging to be a tax practitioner these days because, well, for starters, there's so much tax law that you need to know. Then you've got to overlay things like this superannuation side of things, which is a real challenge in itself. If if you're if you're the tax agent for some super funds, but it's only a small number, then you might not be aware of some of these provisions coming through. And that's the challenge. There's ongoing CPD obligations and requirements. But if you see the wrong thing, or if you see the taxpayer, your client, the taxpayer, you think that they're doing the wrong thing, there's an obligation now to report, or there will be. I think it's from 1 July 25. So there's like these dibby dobber provisions coming through that, again, making it challenging for tax agents and accountants and advisors to be working in this space. Um, but you don't, I mean, it's one of those things also, you don't know what you don't know. So there's so much that you need to know technically from a tax perspective. So I guess the moral of the story and what I'm talking about here is we've just got to exercise a lot more care when we're advising our clients.
Yeah, I think the impact statement that you read out is very pertinent here because the acknowledgement of mitigating circumstances with the involvement of advice, that is, to me anyway, if you want to interpret it like this, that's almost opening the door
Mm.
to say that, oh, yeah, you got, poor advice or whatever, misguided advice, however you want to describe it. But that's almost opening to the door to say that, oh, it wasn't all while we're obviously saying that you have ultimate responsibility, it wasn't all your fault,
Mm.
right? Basically, that's what it's saying. So doesn't that start to get the wheels in motion in the individual's mind to say, oh, okay, well, if it wasn't all my fault,
Whose fault was it?
who else's fault
Yeah.
was it? And of course, the fact that you don't even have to you don't even have to go down a very long path to do this. The fact that the statement said that he got advice was a mitigating factor. They've already identified potentially who else's fault it was.
Yeah,
So
exactly.
that's
Yep.
that's opened the door, and as we always say with human behaviour, this has got nothing to do with SMSF trustees. Very seldom do they put their hand up and acknowledge complete fault on
Fault.
their own,
Yep.
and especially if there are tax penalties coming along, or obviously loss of income in some way, shape, or form, they're going to want to get some compensation because
Mm.
the reality will be, well, why the hell should I shoulder all of this on my own? And actually, the AAT said this, right?
Yeah.
I think we've got an avenue to at least sort of lessen the liability that we might face here. And of course, then it turns onto the advisor. And the bad thing
And their
about
PI insurer.
well, I was about to say this, Gemma. We've
Yeah.
already seen court cases, recent court cases in the past where probably from a logical perspective, maybe the decision handed down by the court didn't make 100% of sense, or it could be reviewed as, whoa, that's a bit harsh. And that really, you do look at some of those and think, whoa, that really is a long
Mm.
bow to draw if you're going to find fault with one of the parties. And of course, some of the justification was that the practitioner, the professional, whatever you want to, whoever you want to describe it as, has professional indemnity insurance. So,
Yep.
in other words, there is a mechanism of compensation there to allow the consumer, whoever it might be, the client, to get an outcome so that they're not as financially penalized as they would be if they were going to,
Mm.
shoulder the whole burden on themselves. And potentially the advisor's not going to be massively penalized because he can just make a claim to his PR insurer. Now, he or she might be penalized in future because obviously the premiums might change because you've had to make a claim against your PI. But the
Mm.
whole thought behind the court process is that, well, he's got a safety net as well. So why don't we
Yeah,
just draw on that pool of money, and then everybody's happy here? It's not
yeah,
really the right way to go about it, but if they're looking at doing that, hey, look, the advisor's in the gun. No, no,
yeah.
no two ways
No
about
doubt. No, well, the other thing, and on a previous podcast, we've spoken about the sophisticated investor certificates, and I know again I'm digressing a bit here. And there was that AFCA case where the
it.
person
Yes.
lost money because the accountant had signed off to say, "Yep, you've met the criteria," but then they lost money, so they said, "Oh no, I didn't," but you signed off that I did, so therefore you're on the hook. And I think the
Yeah.
outcome of that was, well, yes, but at the same time, you contributed to that because you knew that like that's what you were investing in, and etc. So that contributory side of things happens. The other thing with the PI that I think is going to be interesting in this case is so you've got this, and it might be not on the super fund angle, but on the trust angle. So if it's on the trust angle, it's probably a bit different. But the PI cover that the firm will have, that the advisory firm will cover certain tax elements to do with the trust. And it'll be interesting to see how they go on the AFS. Like, is there an AFSL issue that happened or didn't happen? So, PI comes in when you've done the right thing and they cover it, they cover the loss. But if is it covered by the PI if you didn't flow through, was there a statement of advice that should have been provided? Was there all these things that file notes might show, oh, yep, Mr. Merchant was advised that he can do this under CIS because of this, and this. It's like, well, where's that advice? That's was he a retail client? Was the fund worth less than $10 million? And I believe that it was. I can't remember exactly now. And so therefore it's advice to a retail client, statement of advice. So again, we await what happens there, and whether the PI does cover it or if it's an alternative. But we probably may not even know what the outcome of that is.
Yeah, no, it's so complex, and I really do have some sympathy for advisors here because, as I said, this piece of advice was no doubt made in the best intention of the client. So you can't say that it's not client's best interest here. But again, looking at the macro view, it's great. It's a great strategy, but this is probably a classic case in point where the strategy becomes a sum of all parts rather than a macro
Yes.
view.
Mm.
And unless you look at all the parts that make up the total, this is where you can kind of fall foul. But I mean, I say that, but it's not always that easy to
No, it's not.
execute when you're looking at doing that sort of strategic planning for a client on a bigger scale rather than
Yeah.
just focusing singularly on their self-managed super fund.
That's right. And I think that it highlights that. So here we're talking tax and super, and we need to take that, keep doing this umbrella holistic approach, because if you've got your blinkers on, you're going to miss something. And to digress again, we see that happening a lot from an estate planning perspective as well. So people are like, oh, with your super fund, you do this, this, and this. It's like, well, hang on. How does that feed through to what are your overall intentions? Because you do one thing in your super fund and it might totally stuff up again the umbrella and your overall intentions. So you can't have the blinkers on and just be looking at the super fund or at the trust. You've got to really consider things more holistically. And that comes down to also collaboration. So if you've got, so again, ignore this matter for a moment, but it's just so important that the tax agent for the fund, the financial advisor for the fund, the lawyer for the fund, or even the auditor, that everyone, where there's a transaction that might be a bit contentious, that everyone is chatting to each other and trying to make sure that they're getting the right outcome, and covering off on all bases, because there's so much out there that the financial advisor might not know about it because they don't have access to the portal, the tax portal. The accountant or the tax agent may only know what happened up to 30 June 24 because that's all they've done. So what's happened since? So again, it's that collaborative approach from that perspective.
Well, I think we might wrap it up there for today, Gemma.
Yeah.
Probably a good point to end it. But look, I just wanted to slip in a Simpsons reference as
It's
well, because
reference.
that's
Yeah, I
what we
was
try
waiting for
to
that.
do. And
Yeah.
I was a bit silly in thinking that you might favour Corona beer when you were talking about the Coronica case or the Coronica case, simply because I know you'd favour Duff beer, wouldn't you?
Yeah.
Because
Well,
that's Homer's favourite.
it is Homer's favorite. Yeah, yeah, yeah. Yeah, yeah,
So silly me
yeah.
for thinking that that reference would be
You got it in
relevant.
there though, Darren.
I
You got
did.
it
I
in
got
there. The
I got both
important
of them in
stuff.
there today.
Yeah,
So
yeah.
again, tick those two boxes like we usually like to do.
And
But
we try
anyway,
to. Yeah.
look, thanks, Gemma, for your time. That was a really great discussion. I think that merchant case is an absolutely massive, um, iconic
Mm.
decision and situation for SMSF trustees, and plenty of lessons to be learned, not only from a trustee perspective, but also from an advisory perspective as well. So really significant case.
Yep. Exactly. Exactly. We've got to be
So
on top of it all.
absolutely. So thanks for your time, Gemma, again today, as usual. Been an
Thanks for having me.
absolute pleasure nerding it up with
Yeah.
you.
I love a good nerding it up. Yeah, it's fantastic. Thank you.
Look, thanks to my production team as well for putting this together and obviously uploading it onto all of our relevant sites. Really appreciate your hard work in the background. But most of all, thank you to you for listening, watching, whichever medium you're enjoying this podcast on. We really do appreciate your support, and we do hope that you get as much enjoyment, but more importantly, as much information out of these podcasts as we like presenting to you. Other than that, we hope to catch you in the next episode of the Cross Country Super Podcast. And until then, travel safely and have a great day.